Court calls the case. People versus Christopher Miller.
Right out of the gate, this courtroom is anything but routine. Judge Simpson is presiding, and within seconds, we're watching a defendant, Christopher Miller, try to navigate a bond issue that's already hanging by a thread. There's tension here, because this isn't a first chance, it's a second. And second chances in a courtroom, they come with receipts. You can feel the gravity when Miller admits he messed up. He's not denying it, he's not spinning it. He's confessing that fear of jail got the better of him. But here's the twist. Judge Simpson already gave him a break before. Not only that, the judge let him step out to test, and within 20 minutes, he blew numbers. That's not a technicality, that's a credibility collapse. Legally, this is about bond conditions. When a court grants bond, especially after prior violations, compliance isn't optional. It's the price of freedom. If you violate it, especially while standing before the same judge who just showed you leniency, you're burning through judicial goodwill at record speed. So now the real question becomes, does remorse outweigh repeat behavior? And when a judge says, "I'm not changing your bond," that's not just procedural, it's a message. In this courtroom, accountability isn't symbolic, it's enforced. Stay with this one, because if this is how the morning starts, you already know the rest of the docket is going to be wild.
Get away from me and take your chair with you.
Andrew Childers appearing on behalf of the people.
Good morning, Your Honor. Edward Dukas on behalf of Christopher Miller.
Your name, sir?
Christopher Miller, sir.
Thank you. You're requesting an adjournment.
Yes, I'm looking to obtain the video, and I've spoken to the prosecutor about it.
That objection, probable cause conference will be adjourned to February 27th, 2025, 9 a.m. Bond continued.
May I say one thing, sir?
Okay, go ahead.
Your Honor, he would like to address bond just briefly.
Oh, okay, go ahead.
I'm sorry. I'm gonna say this myself, sir. So I did mess up, sir. I was nervous about going to jail, and I did mess up and take a shot, and I would say that. But I did have a lot to think about while I was in here last, on account of.
Did you?
Yes, because what
What?
had happened was something happened to my wife while I was in there. She had a miscarriage, and I wasn't even able to be there for her while she was in there. So that kind of like really sunk in that I messed up this time, especially after you gave me a chance, sir. So I was just trying to see if I could possibly get a new honor, try a chance to show you.
Mr. Miller, so that we're clear, Mr. Dukas made a very eloquent argument for you. It would be typically something where I would have blocked you off. I got sort of wooed by Mr. Dukas. I let you go, told you you needed to go over and to test.
Yes, sir.
Sitting in my chambers. Wasn't 20 minutes. You went over and you blew numbers. If I had done what I normally did, we would probably not known that you had been drinking, but I did.
Yes, sir. I understand. Like I said, I've just really been trying to take care of this situation. That's why I turned myself in on it. Like, this is something that I wanted to address because I do have a good job, sir, and I was trying to get everything taken care of. And I promise you would give me another chance.
Twice. I gave you a break the first time. You messed that up. You were standing before me after having drank. I let you go over. You tested positive. I'm not changing your bond.
This moment right here is the turning point for Christopher Miller. The judge lays it out clearly. 2 chances, 2 opportunities, and both times the defendant failed to follow through. In bond hearings, judges evaluate 2 major things: risk to the community and risk of noncompliance. Miller's own behavior just answered both. What makes this more powerful is the judge's transparency. He openly admits that normally he would have cut Miller off from speaking. But he was persuaded by defense counsel. He extended grace. That's rare. And when that grace is immediately followed by a failed alcohol test, that doesn't just look bad, it erodes trust. Here's the legal reality. Bond isn't a reward. It's conditional liberty. When you violate those conditions, especially by consuming alcohol when you're clearly under court supervision, the court isn't obligated to keep negotiating. And let's talk about something deeper. Miller brings up his wife's miscarriage. That's heavy, emotional, human. But courts don't operate on emotion alone. They operate on conduct. Judges can empathize and still deny relief. Those 2 things can coexist. So here's the question for you watching. Should personal tragedy weigh more heavily in bond decisions, or does repeat violation cancel out sympathy? Judge Simpson makes his answer clear. Accountability wins.
Yes, sir.
Thank you.
Thank you, Your Honor.
That is why Drukas wasn't speaking. There was nothing to say.
Your Honor, may I make a brief request as to bond?
Yes, you may.
Thank you, Your Honor. Since coming into custody, very unfortunately, Mr. Pinkston has had to have emergency gallbladder surgery. It is my understanding that that took place this past weekend. He was taken to the hospital, then of course brought back to the jail. Since I've been meeting with him, I've personally seen a steep decline in his physical health. He is in severe pain. I have spoken to his mother, who resides in Monroe, with Mr. Pinkston's stepfather. He's asking that he be released on both cases on a PR bond. The only other thing holding him is a $100 bond on a DWLS out of 15th. We're asking that he be released today on a PR bond so that he can reside at home with his mother in Monroe while recovering from his surgery. These cases are nonviolent allegations. He has waived his right to a preliminary exam. We ask that he be released today on these matters.
Ms. Lundy.
If I recall correctly, I'm pulling up my notes now to double check, but the defendant was out on bench warrant status in the 24F4 matter for some months and only came back in to face these charges as a result of being picked up new possession of methamphetamine case, the 25 case, where he was, I believe, found slumped over, semi-conscious in a vehicle that was parked at a gas station, I believe. And then the drugs were found in his vehicle. So I am concerned that if he is released, will not remain law-abiding.
Respond, Your Honor.
Sure.
He's in a wheelchair. He's in severe pain. He would be staying at his mom's house. I have zero reason to believe that he would commit any sort of failure to appear even, or any bond violations of any kind. He would be more or less bedridden, staying with his mother. His mother is not a drug user and does not have drugs in the home. I would be asking that he be released so he can deal with these cases while recovering at home.
Motion for bond reduction is denied. Defendant, he picked up the new case while he was out on bench warrant status on this one, from my understanding.
I understand, Your Honor.
Thank you. All right, Esteban.
Your Honor, Esteban, Mr. Williams was picked up yesterday on a tether violation. His tether died. He did have a $10,000 personal bond prior to that. I spoke with my client about that. His tether needs a new cord. So I think as long as we get a new cord, like a charging cord. So I think as long as he can get that.
Seriously?
Yes, Judge.
That's all it was, Your Honor. I just needed the cord, and I borrowed a friend, and then we got mad, took it back or something. It was crazy. It happened quick. It started beeping, and I said I was so tired.
Hold on a moment. So where's the cord?
The friend, the guy that I got through between the two, which cord was which? One was damaged, one wasn't, and so it was confused between the two, which cord was one. I didn't want to get into a whole, you know.
Hold on a second. Did the cord go back to community corrections?
I could refund it as soon as possible. I could pay for it, sir. But I don't know. I don't know where it went to. I fell asleep and woke up and it was gone. You know what I mean? Certain different things. I'm not sure what happened to it.
Was this at the homeless shelter?
Yeah, it was at the shelter. So I stayed at the shelter. So, you know what I mean? I just woke up and my stuff was scrambled through. And I'm like, man, is that my cord? He's like, no, it's not. This is my cord. So I just left it alone. You know, you can't, something like that.
Did you do that? Because
it was one or 2 days, like 1.5 days I had the cord.
Well, if the guy took your cord, why didn't you call community corrections? Tell him that other guy's got my cord. I need a new one.
You didn't think to do that?
I was about to, but I didn't get around to it in time. They called me before I could get up there.
I don't need a response. Motion for bond reduction denied. Bond will continue.
Thank you so much, Your Honor.
What is that?
He said it's- Thank you, Your Honor.
Yes. Thank you. Ain't that an answer? It sounded like a story I had with my phone charger. I woke up, somebody took my charger. Rushing. Did you think that was gonna work? No, don't even answer. No, I'm just asking.
They have some experiences that happen to them.
No, I agree. I agree. Yes,
Thank you.
Mr. Brown.
As to bond, Your Honor, my client's in a family way. She's 30 weeks pregnant.
I understood what you're.
I figured.
Go ahead.
She is 30 weeks pregnant, Your Honor. She's very high risk. She was given a prescription before she started this pregnancy, and that prescription has not been given to her in the jail. She has no prenatal care while in the jail. She's already had an incident where she's had to go to the hospital once while in custody. I am asking for her release. She advises that she can stay with her fiance. No one involved in this matter. I believe the complaining witness is a minor child that she has no contact with currently. And she has no contact with her mother either. I'm asking that she be released.
This next case shifts the emotional temperature again. A 30-week pregnant defendant. High-risk pregnancy. No prenatal care in jail. That's serious. And now defense is asking for release so she can stay with her fiancé and avoid further medical complications. Legally, pregnancy alone doesn't guarantee release, but it absolutely factors into bond considerations, especially when medical care access becomes a concern. Then comes the complication: no contact orders with 3 minor children, who are, in fact, her own children. The court now has to thread a needle between child safety, alleged charges, and maternal rights. And then comes one of the most unexpected courtroom exchanges. The prosecutor raises the question: if she gives birth, technically the baby is a minor child. Would that violate bond conditions? The courtroom laughs, but beneath the humor is a real legal question about how broadly no-contact provisions apply. Judge Simpson handles it with clarity. He sets a $50,000 personal recognizance bond and clarifies that contact with her newborn would not constitute a violation. This is judicial discretion in action, balancing protection with practicality. Here's something to think about. Should pregnancy significantly influence bond decisions? Or should the charges outweigh personal circumstances? In this case, the court carved out space for humanity without removing accountability.
As she is 30 weeks pregnant, going on 31, obviously, and she's...
So the child that is the subject in 1006 is not her child.
It is my child.
It is, Your
I'm
Honor.
understanding it is her child. I believe the child is now with a different family member. And so that would be our biggest concern, is that make sure that there is no contact.
You have it,
Yeah.
Well, who's the child with? Do we know?
My child's father, Your Honor.
That's our understanding, Your Honor, is that the child's with its father.
Was there anything else in the case?
No, Your Honor, I'll leave it to the court's discretion. I've been talking to Mr. Ballinger and one of his colleagues previously about resolving this case. Well, we want to see Ms. Solomon work on herself, and I think we can reach a resolution. I think she can be an excellent mother if she gets some things figured out.
Without saying the names on the record, I have 3 names listed on her bond form of for no contact. Is one of those individuals child?
All 3 of them. All 3 of them are. All 3 of my children.
So they're all 3 your children that are
Yes.
Your Honor, we had requested no contact with any minor. I don't know if that's going to be an issue, but that might be.
That will not be an issue.
Okay for now.
That won't be an issue.
That will not be an issue, Your Honor. She advises that she can stay with her fiance. He lives in the city of Westland. She would not be in the vicinity of children.
Then let me ask this: is CPS currently involved?
Yes, Your Honor.
Okay.
I haven't had any contact with them since I've been in here, besides to discuss whether or not they were going to do a mandatory custody petition.
I know that they are working eventually on reunification, Your Honor, but at this time she hasn't been.
That doesn't. Okay. All right, guys. All right. Since the no contacts are already in place and given what counsel's indicated, defense counsel's for. I'm going to add a provision of no contact with any minor children. I'll set her bond in the amount of $50,000 personal recognizance bond.
And Your Honor, if I may, my concern is that if she has the baby would be a minor child, obviously. Would she have permission to?
You are so bright.
It is a concern.
Your brilliance amazes me every week, Mr. Bellinger.
Just wanted to make sure that she'd be allowed to.
Okay, Mr. Bellinger, I hear you. Do you really think I would find a bond violation?
I don't, Your
Because
Honor.
she's in contact with.
I don't, Your Honor. But I just want.
So you're just going to talk about it.
You never know. You never know with these prosecutors, Your Honor.
We're a bunch of troublemakers up here. We like to do our job.
Too well sometimes.
Wow.
Too well.
Wow. Boy, I know. Just. Okay. Did you want me to make that exception?
Yes, Your Honor.
No, I'm not going to make it an exception. It's not going to be a bond violation.
This moment right here is classic Judge Simpson, firm, sharp, but grounded in logic. The defense attorney pushes, perhaps a little too far, asking whether contact with her own newborn would technically violate the no contact order with minors. On paper, it's a fair clarification. In practice, it nearly overcomplicates the ruling. The judge's reaction says everything. He almost reconsiders out of sheer frustration with how tangled the scenario is becoming. Why, that's an important lesson in courtroom dynamics. Sometimes pushing too hard can backfire. Judges appreciate clarity, not hypotheticals stacked on hypotheticals. Legally speaking, no contact orders are interpreted with reason. Courts are not in the business of creating absurd results, like preventing a mother from holding her newborn absent specific safety concerns. By refusing to carve out a written exception, Judge Simpson essentially signals confidence in common sense enforcement. Not every scenario needs to be micromanaged into the bond language, but notice something else. The prosecution and defense are sparring lightly, even joking about overzealous prosecutors. That levity masks something deeper, the constant tension between protecting victims and preserving rights. Quick question for you watching. When attorneys press for clarifications like this, is it smart lawyering or unnecessary risk? The takeaway here, judicial discretion isn't just about rules. It's about judgment, and sometimes restraint speaks louder than amendments.
Okay, thank you.
It's just not. I mean,
Thank you, Your Honor.
he almost blew it. I almost said this is going to get too complicated. So
We got some overzealous people working here, Your Honor.
All right.
I do appreciate everything that you're doing, Your
No
Honor.
offense.
Mhm.
Take care. Good luck to you.
You too, thank you.
All right. We'll be in touch, okay?
What did they have this? Because if the baby's born, that'll be a child. It's just brilliant. No, brilliant, brother. Courthouse case.
May I address a tether issue very briefly?
Briefly.
Judge, I don't think the prosecutor is going to object to this. My client's wearing a tether. We've discussed this before. She's a top chef which is extremely professionally embarrassing to her. She lives in Wayne County. The alleged victim lives in Ann Arbor. It's about 40 minutes apart. There's been no contact on her side. The victim is continually calling her, would like to repair the relationship. That all being said, my client has not answered any phone calls. She's not a threat. She will not go to Ann Arbor except to meet here in the courtroom, Judge. And she's asking that because she's a professional. It's truly embarrassing for her to be walking around as a chef wearing a tether. We're asking that you allow her to take that tether off.
We're now dealing with a completely different kind of argument. Reputation versus restriction. Defense is saying this tether is professionally embarrassing. She's a chef. She works publicly. It affects her image. But here's the legal reality. Bond conditions are not designed around convenience or optics. They are designed around compliance and safety. Judge Simpson's response is sharp for a reason. When he says, I suppose incarceration is less embarrassing. He's reframing the argument. The alternative to a tether isn't comfort, it's custody. Pretrial supervision is already a form of judicial leniency. A tether is a monitoring tool, not a punishment in itself. The prosecution doesn't strongly oppose removal, which signals that risk assessment here may be relatively low. And that's key. Judges weigh prior behavior, contact with alleged victims, and flight risk. In this instance, the judge crafts a middle ground solution, tether removed, aiming to put strict geographic restriction, no entering Washtenaw County except for court. That's not softness, that's structured discretion. Question for you, should professional embarrassment carry weight in bond decisions, or should the court ignore optics entirely? Here the judge balanced dignity with boundaries.
I suppose incarceration is less embarrassing.
I'm sorry?
Never mind. Response from the people?
Your Honor, leave it in the discretion of the court.
Well, other than court proceedings, she has no reason to be in Washtenaw County, is that right?
No, I don't.
We're gonna need an order in. I will order that the tether can be removed effective today. The defendant is not to enter Washtenaw County under any circumstances except for court-related proceedings.
Thank you, Judge.
Yes, sir.
This is probably a stupid question, but that also,
Probably is. Go ahead.
seeing me at my office at Ypsilanti, I mean, this
That
is,
would seem to be a court-related proceeding.
that's what I thought. Thanks, Judge. Really appreciate your consideration.
Stephanie Cannon, on behalf of, sorry, Your Honor, he is not here. Thank you. Thank you. He was just right there. On behalf of,
He was just right.
Terrence Robinson, he was, Your Honor, he was like this tall.
So when you said he's not here, you mean he's in the building, he's just not.
Yes, he is here. We just met. He came in right behind me. I don't. Your Honor, yes, he's the very tall one.
Light gray sweatpants.
Yes.
Wow.
She saw him too.
Apparently.
That does not seem to.
It also describes the Jolly Green.
He did also check.
So
Your Honor, can we just pass this for a few more minutes?
if I said no, what would you do? You don't know. I'll pass it.
Thank you, Your Honor.
Seems to me if you look in the hallway, given that description, you can't miss it. Court calls the case, People versus Michael Rudisil.
Stephanie Cannon.
You don't have that one either? Cannon, you don't have that client either. You know what? All right, I'll pass that. We'll just pass it to the Cannon docket. Not this one.
Oh, you know what?
Court does call the case of the People versus Terrence Robinson.
Now we shift to Terrence Robinson, and the energy changes immediately. He wants a preliminary examination. That's his constitutional right. A preliminary exam determines whether there's enough probable cause for the case to proceed to trial. No drama there. But the tether issue quickly complicates everything. The judge explains that there may have been a communication failure between arraignment and community corrections. That's significant. If documentation wasn't transmitted properly, then confusion about the GPS order isn't necessarily willful defiance. And here's the important part. Judge Simpson explicitly says he will not find a violation because he doesn't have a clear narrative of what happened. That's judicial caution. Courts cannot punish based on assumption. But then comes the reset. Once the judge tells Robinson directly that a judicial officer ordered GPS, compliance becomes his responsibility from that moment forward. No more gray area. So ask yourself, when the system miscommunicates, where does accountability land? In this courtroom, the answer is clear. Clarity ends excuses.
Stephanie Cannon on behalf of Mr. Robinson, who's appearing to my right. Mr. Robinson, could you please state your name for the record?
Terrence Robinson. My mother is here too.
Your Honor, my client has decided that he would like to exercise his right to a preliminary exam.
All right, I don't have a problem setting a preliminary examination. Council Pro.
Yes, Your Honor. I want you to read this. I want you to understand what he's going to talk to you about.
I guess, yeah, I didn't.
Okay, so here's part of the problem.
Those are terms of probation for guilty people.
Okay, Mr. Robbins,
Don't talk unless the judge talks.
you're gonna need to be quiet now. Okay. All right. So I gave you a copy of the bond violation report, and the bond violation report indicates that the defendant was placed on the tether per court order. And hasn't been keeping it charged. There's also an indication that he was released from the jail, and the jail nor community correction staff knew that he was to be placed on a GPS tether. However, no court documents spoke and they were released. So the issue, my staff thinks, but we don't know, may have really been our communication system that from arraignment would have sent those documents to the various agencies.
Understand?
Okay, so that may have been it, and why when the request for the warrant came over, I did not sign it because I wasn't sure. I mean, I could see it in the file, but I did not have a narrative of what allegedly transpired. Okay, so I'm not going to find a violation or anything, and I don't have a problem. He wants it set for preliminary examination.
He does, Your Honor.
All right. So, Mr. Robinson, here's going to be the problem, and I can overhear you when you were talking up there. Whether or not I put you on it or not is, in certain respects, irrelevant. A judicial officer has ordered you on the GPS tether. So what I'm going to suggest to you is that you comply with that order. Okay?
I will, because you told me.
Okay. So you got to make sure to put that on, have it charged. Okay. You got it?
This is where Judge Simpson tightens control. He tells Robinson plainly, I don't want to get a report saying it's not charged. Now that you know, I expect compliance. That's not hostility, it's boundary setting. Bond supervision works on documentation. Reports get generated automatically. If a tether dies, a violation notice follows. Judges don't want surprises after giving warnings. And Simpson makes that clear. Now that I've told you directly, future non-compliance won't be treated as confusion. This moment is important because it shows how courts transition from uncertainty to expectation. Earlier, there was administrative doubt. Now there's none. And notice Robinson's tone. He tries to agree, tries to reassure, but reassurance doesn't replace follow-through. Here's the engagement piece. Once a judge personally warns you in open court, do you think future leniency becomes harder to obtain? Absolutely. The courtroom is documenting responsibility in real time.
So I don't want to, so I'm just going to be blunt with you. I don't want to get a report saying he doesn't have a charge, because now I know I told you. Okay? And you can be mad with me if you want, but you know how I am. If people get mad with me, I don't care. Okay?
I don't get mad.
Okay. So then the next thing is, so I want you to do that. Now, the next thing is, and what I'm worried about, you haven't been taking anything, have you?
I've been going into recovery, and during this process, I have fell off the bandwagon. So
You did what?
I have fell off the bandwagon. I've been trying to get into recovery. I was at the hospital going into home of New Vision. They wouldn't let me in there because I didn't have my meds. The jail took my meds. They won't let me in there because I don't have my proper prescriptions to come in there. And when I tell you it's been a runaround.
Okay. All right. Hold on a second. So here's what I hear you saying to me. Okay. And you tell me if I'm wrong. You're supposed to be on certain medications.
Yeah.
You're not on those medications right now because for whatever the reason is, you don't have access to them. Right? Okay. So now do you get those medications through your doctor or are you with CMH?
CMH.
You're with CMH?
What is CMH?
Community mental health.
Yes.
Yes, that's okay. So that's where you get those, right?
Yes, and to save a long story, it's just there's a problem with my insurance and all this type of stuff. But I'm still working on that. But the jail would have just gave me 1 minute.
Okay, hold on. Just
I've been all right.
Red, let's do this. Let's step away from trying to blame anybody. Let's get you back on your meds if you can. How about that? Fair enough? Okay. So it's you. Ken.
It's 100%.
No, it is
It's
100%
100%
you.
me.
It is you. Everything was going fine my whole day,
It was.
and then you. Yeah. All right.
Your
So-
Honor, is there a way for me to go to the jail to get his meds? Is that, will they release his?
I don't.
To me?
I don't know what the jail has done with
So
those.
the problem is apparently they had just been refilled in their psychotropics, so.
And so he can't, right, okay. So I don't know.
Okay.
And what I'd suggest that you do is you call jail, see what, no, I know you called the jail. I'm gonna have other people call.
I got something else for you.
Okay.
Permission to speak?
Yeah, go ahead.
I talked to my brother Andrew Robinson, the sheriff. He talked to the captain. The captain told me exactly what I was supposed to do. The captain of Washington County. I'll go fishing, whatever, don't matter. But they said to tell them I have identifiable meds. So I have to call him again. But he said if I don't say it like that,
Okay.
I don't understand what I'm saying.
Just listen. But why don't we do this? I'm gonna let your attorney work on that.
We'll get,
Okay.
we'll do it together today, okay?
Okay? Because maybe she doesn't have to say the same things that you say.
Okay.
Okay? So we're gonna do that. And then because of the, oh, we need a new order.
I did verify that, yes.
Yeah, okay. So that hasn't been charged.
That I don't know.
No,
I mean,
he
like
hasn't
monetarily
charged it. He hasn't charged.
Okay.
Oh, probably.
Yeah. Right.
He hasn't.
And okay, so I'm gonna let your attorney check into that, see if they can get it back. You have a worker with CMH?
Yes.
Have you okay? Have you talked to them?
Yes.
Okay.
But I'm telling you. This tether right here is giving me a hard time.
No, the tether's not giving you a hard time.
Okay, well then maybe it's not the tether.
No, it's not.
Me not having my meds.
That's what's that. I got you.
I cannot.
That's what's giving you a hard time.
So it's causing me to come back out into a world that I've been long far away from.
I hear you. So that's why what I want to do first and foremost is I want to get you back, see if we can get you back on your meds. Okay? So I don't want you worrying about the tether. Don't let that bother you. You get angry with the tether, then get angry with me. Okay? Because I'm putting it on you and we're going to sign a new order so that happens. Here's what I want you to do. I want you. So, Ms. Cannon, you're going to try to check into that and.
It's my last case, Your Honor. I'm going to go address it now.
Okay. So we're going to try to see what we can do for you on that end. Okay? Make sure to give Ms. Cannon who your CMH worker is so that she can reach. That's Ms. Cannon. Okay? So that she can reach out if she needs to that person, as well as talk to the sheriff's department and see about this other thing. Okay? All right. But one thing I want you to do is I also want you to get yourself over to community corrections and make sure your tether unit's working. Okay. Now, Mr. Robinson, your counsel's asked me to set this for a preliminary examination. Is that what you want right away, or you want me to adjourn it out a couple weeks and see where we are and sort of monitor where your meds are and stuff like that, and then make a decision what to do with your case?
A speedy trial, because this was very.
Okay, I don't want you talking about the case itself.
Speedy trial.
Okay, so you want, all right. So let's do this then. And Miss Cannon, your discovery is complete.
Your Honor, this is actually Attorney Feaster's case, and I'm so happy he has shared it with me. And he told me
You know, a little bit more sincerity in your voice. Great.
he told me to
Go
set
ahead.
it for preliminary exam, so I'm going to have to
Oh,
say
that's
to
what
the best
he
of my
instructed. Okay.
knowledge that
That's
the
fine.
case is ready to move forward.
All right. And would the people be able to have their witnesses available the 25th?
Yes, Your Honor, we'll do our best. And
All
I'd
right.
just like to address one matter before we're all done.
Okay, that's fine. So what I'm going to do is I'm going to give you your preliminary examination. Okay. I'll set it in person, February 25th, 2025, 9 a.m. And I'm going to set that before me.
Okay, thank you, Your Honor.
Okay. And then, yes.
Your Honor, thank you. As I indicated at the bench, I have some concerns in the moment about whether or not there's impairment in play also. I understand we've discussed mental health issues that may be in play. Strangulation occurred when high. My concerns are certainly endeavoring to address all these issues. I'm worried we're going to have somebody walking out of the courtroom that doesn't have a tether on them. Probably has mental health issues in play and may or may not also be impaired. At least order test maybe. Or
I am going to order So let me ask you this.
I wanted to treat me, Your Honor.
No, just listen. Listen to me, okay? Because I'm going to need you to do some things. All right? And I'm going to ask you a question. I just need you to be honest with me.
Yes.
All right? If I send you over now for a drug test,
I'm gonna drop dirty, sir.
you're going to drop dirty?
Yes.
Okay. Let me ask you
That's
this.
it.
Hold on. Just hold on.
This is the pivotal moment. The judge asks a direct question. If tested right now, would you test dirty? Robinson answers yes. Cocaine, alcohol, possibly prescribed substances. That honesty is striking. Most defendants hedge. He doesn't. But here's the legal impact. An admission of cocaine use while under court supervision changes everything. Judges have a duty to protect community safety and ensure compliance. Active drug use signals instability. Notice the judge's tone. Now I'm really worried about you. That's not sarcasm. That's recalculation. This is no longer just about tether paperwork. It's about whether Robinson is safe to remain unsupervised in his current state. Engagement question. Does voluntary honesty about drug use reduce consequences or accelerate intervention? In this case, honesty triggers immediate judicial action planning.
Ms. Robinson.
What's going to show up in your system?
Cocaine. It would be cocaine. It would probably be alcohol from last night. And it would probably also be, I did get it, but I'm prescribed that.
Okay. So let's do this.
And Suboxone probably be there too.
What do you say?
I'm prescribed Suboxone. So I'm staying away from.
Hold on a second. So you're prescribed Suboxone.
Yes. So what I am doing is, what do you call it? I'm self-medicating because
Yeah, I know.
I can't get my meds.
Okay.
This is not, I don't do this. This is not what I do.
Okay. All right. So didn't necessarily expect all of that.
I'm gonna keep it real.
So, Mr. Robinson, here's what I'm gonna do. We got to change the plan.
When Judge Simpson says, we've got to change the plans, that's the turning point. The preliminary exam discussion pauses. The focus shifts entirely to safety and stabilization. Robinson pleads not to go to jail. His anxiety spikes. His language escalates. But the judge remains measured. He proposes verification. Contact new vision. Confirm treatment. Confirm medications. This is not automatic incarceration. This is controlled intervention. However, once bailiffs are instructed to take him in temporarily, the courtroom dynamic changes. Robinson realizes control is slipping away. Legally, when a defendant admits active drug use and supervision violations, a judge can modify bond immediately. That authority is broad. Here's the question. Is the judge overreacting or responsibly responding to new information? Given the admission of cocaine use, many judges would immediately revoke bond. Simpson instead seeks verification first. That's discretion in action.
Okay, I'm just gonna let you know. Because now I'm really worried about you. Okay.
I need my
No, you need to listen to me.
Don't take me to jail.
Huh?
You really about to put me in jail? I'm going to
Tell me, hold on.
I'm going to go through everything.
Mr. Robbins, Mr. Robbins.
Home and New Vision is waiting for me right now. Once I get my meds, and you can, this is all verified.
So just listen. Here's the way I'll do it. I am gonna
do not arrest me.
Just listen to me, because I don't want to make this any more difficult than it has to be. Mr. Robbins.
I'm listening.
Now, here's what I want you to do. I'm going to have my bailiffs take you in. I'm going to ask counsel to call. Just listen. I'm going to have your counsel contact Home and New Vision. If they tell me what you said and we can get your meds, then I'm going to let you right out and let you get there.
This is conditional mercy. Judge Simpson lays out a path. If treatment placement and medication access are verified, release remains possible. That's a huge distinction. He's not slamming the door, he's requiring proof. This shows how courts often operate with addicted defendants. It's not purely punitive, it's compliance-based. Show structure, show a plan, show supervision. Robinson's emotional reaction, fear of jail, is raw. But fear doesn't override procedure. From a legal standpoint, the judge is protecting the record. If something happens after a known admission of cocaine use and the court ignored it, that becomes liability. Engagement question: should courts act as treatment coordinators, or is that beyond their role? Today, the judge stepped into that coordination space, carefully.
Yeah,
okay. I don't know.
I swear before the court, Your Honor.
Mr. Robbins.
A bid for me.
Mr. Robinson.
I don't want to go in that motherfucker. Shit.
Okay.
Sorry.
I ain't going to take those words.
I apologize.
My bailiff's going to take you. We're going to check on some things and figure out. Go with my Mr. Robbins. Just go with my bailiff. Because if you make it difficult, we're going to have a real problem.
Actually, you can drop me. I'm probably clean. That was a good.
Yeah, go ahead. We'll figure it out.
The shirt from?
All righty. No, thank you. All right.
This is, by the way, this is,
well, yeah, that's kind of his. Okay, so
today's docket delivered a powerful cross-section of the justice system in action. Christopher Miller learned that repeated bond violations erase judicial patience. Personal tragedy doesn't override compliance. Mr. Pinkston's medical emergency was weighed against a history of new charges while on release, and accountability prevailed. A pregnant defendant received a structured opportunity for release, with strict no-contact conditions clarified in real time. Yafrir, a professional, sought relief from tether restrictions and received conditional geographic limits instead. And Terrence Robinson's hearing transformed into a live confrontation with addiction, mental health instability, and supervision responsibility. Judge Simpson balanced compassion with caution, offering verification before revocation. The common thread across every case: bond is conditional liberty, and conditional liberty requires trust. When that trust breaks through drinking, drug use, even missed communication, or new charges, the court recalibrates immediately. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.